So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. Now in this lecture series, we are covering the subject of polity. As you all know, in the Prelims Powerplay series, we will cover all the important topics from all the subjects in the past 1 year current affairs. Okay, so all the important topics that featured in past 1 year's current affairs would be covered as subjects. Okay, we have merged them or divided them into subjects and we cover each and every subject one by one. So currently it's the turn for polity, and within polity we have covered a range of topics. Today we are going to start with judiciary. Okay, so all the important current affairs, all the important topics that are important from the perspective of them featuring in your prelims examination this year with respect to the subject of judiciary shall be covered in today's lecture. Okay, so without further ado, without further delay, let's start today's lecture. Let's start with judiciary. Okay, all important topics related to judiciary that have a high probability of featuring in your exam. Now within this topic of judiciary, we will cover following subtopics. Okay, well, we'll cover 1997 Judicial Code of Ethics because there were serious allegations of corruption that were leveled against a Delhi High Court judge. Okay, some bags full of cash were found at his residence, official residence. So it brings into question Judicial Code of Ethics. So we'll talk about this. Then we will talk about National Judicial Appointments Commission, NJAC ruling. Okay, NJAC was enacted through Constitutional Amendment Act, but Supreme Court struck it down. So what was this NJAC? We'll talk about this. Then recently Lokpal gave a judgment, okay, with respect to High Court judges. But the Supreme Court struck that down. Not struck it down, but stayed that order. So there is a tiff of sorts between Lokpal and judiciary. So what is important for us to know is what is Lokpal and what is this judgment of the Honorable Supreme Court. Then we'll talk about the issue of ad hoc judges, and then we'll talk about the issue of removal of judges. Okay, impeachment of judges. Clear? So let's start discussing each and every topic one by one, starting with 1997 Judicial Code of Ethics. Okay, so topic number 1. Judicial Code of Ethics. Now, the thing is, and it is very important, you see, there is a very famous saying that perception of justice is important than justice itself. Justice is important. We need to do justice in society. But the population or the people should also feel that justice is being done. Perception of justice is more important than justice. Because if people feel that there is no justice in this society, then they would search for alternative methods of seeking justice. They would take law and order in their own hands and law and order machinery would break down. Therefore, people in India should have full faith in India's judiciary. But what happens is, and this happened recently, that some bags full of cash were found at the official residence of Delhi High Court judge. Okay, well, those were burnt bags full of cash. Okay, burnt notes were there, but still, that raises the question of judicial accountability. Okay, what if the judges who are, there to provide you justice, what if some of them are corrupt? Okay, this debate has ignited recently with that news. Now, the thing is that the process of removing these erring judges is also very difficult. In our constitution, there is a provision to remove judges, but that is very difficult to do. So far in India's history, no judge has been removed, whether that's the judge of Supreme Court or High Court. So how will we ensure judicial accountability? Okay, how will we ensure that? Because it is difficult to remove them, and we'll talk about the removal process. The thing is that in 1997, Supreme Court of India realized that fact, and they came out with Judicial Code of Ethics. In that, they listed out some points that each and every judge should follow so that it will ensure proper conduct of judges in India, ethical conduct of judges in India, and people's faith in judiciary would be reignited. Okay, so if each and every judge follows that 1997 Judicial Code of Ethics, that would be a good thing. It would instill faith in judiciary, and that would be a very good thing for India. Clear? So let's talk about this 1997 Judicial Code of Ethics. Okay, so 1997 Judicial Code of Ethics. The official name for it is 1997 Restatement of Values of Judicial Life. Okay, now this Restatement of Values of Judicial Life is basically a 16-point guidelines, okay, 16-point guidelines which each and every judge has to follow. Now, these guidelines were basically enacted by Supreme Court in 1997, okay. It is a code of ethics that the judiciary adopted in another full court meeting. Clear? Now, what good will this 16-point guidelines do if judges who are not following this 16-point guideline or judges who are not following these 16-point guidelines are not punished or there is some accountability? What if a judge does not follow these 16-point guidelines and he is able to do his duties? Well, without any, I won't say the word punishment, but without any accountability, okay? So to ensure that judges follow these 16-point guidelines, Supreme Court also created a 5-member committee which will create an in-house procedure. In-house means within Supreme Court there will be a procedure to take action against those judges who are not following these 16-point guidelines. Okay. So later a 5-member committee developed an in-house procedure to take action against judges who do not follow these code of ethics. This in-house procedure was adopted in 1999. Clear? Now, in the beginning of the discussion of this topic, I told you that there was this judge on his official residence, a bag full of cash was found, right? And that basically reignited the debate over or around corruption in judiciary, right? Now, to basically tell the public that judges in majority are not, well, corrupt, well, Supreme Court recently decided that all the judges of the Supreme Court would declare their assets in public. Okay, all their assets, all their investments would be declared in public. This is what Supreme Court has decided. Clear? But Supreme Court will do that voluntarily. Let me tell you that no one can force a Supreme Court judge or a High Court judge to declare their assets publicly. It is not mandatory for them. The Supreme Court has decided to do so only voluntarily. In fact, in 2018, a constitution bench gave a categorical ruling that the assets and liabilities of judges are not personal information for the purpose of right to information inquiries. You cannot release the assets and liabilities of judges in the public. If judges decide to release those assets and that information in public, that judge is doing voluntarily. Clear? So this is important. Now, within this 16-point agenda or 16-point guidelines, there are guidelines like, well, judge must not accept gifts from people. They should basically do fair judgment. Okay, they should be not seen doing injustice. There are so many guidelines, okay, so as to ensure judicial propriety. Now, the thing is, this is also very important and MCQ might be asked. This 1997 restatement of values of judicial life, well, it is not just applicable on Supreme Court. It is also applicable on judges of all high courts of India. So, though it was enacted by Supreme Court, it is applicable on high courts. Okay. So, this Judicial Code of Ethics is a numbered non-exhaustive list of 16 entries enumerating values for judges to uphold and pitfalls for them to avoid. Clear? Now, the thing is that there is this thing, many people are saying that judges should declare their assets in public because all public servants, whether they are ministers, IS officers, government servants, all of them have to declare their assets in public. MPs and MLAs fighting elections, they also have to declare their assets in public. So why shouldn't judiciary, judges declare their assets in public, right? Because that would ensure transparency and that would ensure basically it would erect barriers in front of corruption. Okay. Now, public servants, unlike judges, are often mandated to declare their assets and this information is available under RTI Act. Union ministers, including Prime Minister, declare their assets and those assets, that information is published on the PMO's website. MPs have to declare their assets and submit it to the Speaker, and you can know those assets by filing an RTI application. In fact, anyone who wants to contest elections, well, when they have to file their nomination, they have to declare their assets. So everyone has to declare their assets, but not judiciary. Okay. In fact, in 1997, Supreme Court adopted a resolution that judges would declare their assets to the Chief Justice. Okay. Clear? Supreme Court Judge, Chief Justice of India said that, well, judges would declare their assets and liabilities, but that information won't be available for public. That information would be given to Chief Justice of India. So judges would declare their assets, but that information would be submitted to Chief Justice of India, and it is up to Chief Justice of India whether to release that information in the public or not. Remember this fact, okay? Judges are required to submit their asset information to Chief Justice of India, and it is up to Chief Justice of India whether to release that information or not. Clear? This is something that you need to know. Clear? Now let's move on to topic number 2, which is NJAC ruling, National Judicial Appointments Commission ruling. Now the thing is that recently, just after these questions of judicial accountability were in the news, just after some cash was found at Delhi High Court judge's official residence, well, Vice President of India, Mr. Dhankar, he said that had NJAC been allowed, National Judicial Appointments Commission was allowed, then these issues of judicial accountability or these issues of corruption would have been sorted. Now, what was he talking about? The thing is that in India, judges of the Supreme Court and judges of the High Court are appointed by judges themselves. The appointment of judges in India is done by a collegium system. Now, collegium is a group of judges. Chief Justice of India and 4 senior most judges of Supreme Court, they form a collegium, and they decide who is to be appointed the judge of a Supreme Court, who is to be appointed the judge of a High Court. Okay, so this collegium system, well, basically it creates a lot of problems because people say that, well, India is the only country where judges appoint judges, where judges appoint themselves, right? It is a little weird. In fact, in our constitution also, well, Article 124 basically deals with the appointment of judges of Supreme Court. In our constitution also, it is mentioned that President will appoint judges after consulting with Chief Justice of India and other judges as he may deem necessary. But the thing is that Supreme Court through various cases has interpreted that the advice given by Chief Justice of India to President is binding in nature. And that created collegium system. I'm sure you are aware of this. Now, to replace collegium system, NJAC, National Judicial Appointments Commission, was enacted. Okay, so that, well, it is not just only the judges who appoint judges. Other opinions should also be taken into account. Opinions of the executive, opinions of other walks of life, that should also be taken into account to appoint judges. It shouldn't be the case. It shouldn't be a closed system where judges appoint themselves. Okay, for that NJAC was enacted, but NJAC was struck down by the Supreme Court in 2014. Now, what is this entire thing? Let's talk about this. So, the NJAC ruling. So, first of all, what was this NJAC? First of all, you need to know the constitutional provisions with respect to appointment of judges. So, Article 124 Clause 2 deals with appointment of Supreme Court judges. It says the President appoints Supreme Court judges by warrant under his hand and seal after consulting Chief Justice of India and other judges as he deems necessary. So the Constitution is very clear. The President will appoint judges, but he has to take the opinion of Chief Justice of India and other judges. Okay. But the Supreme Court through various cases interpreted this as that the advice given by Chief Justice of India and other judges is mandatory for the President to follow. It is binding in nature. So whatever CJI would say, President has to follow. So in effect, they are appointing judges. And Supreme Court gave a system. So this CJI plus other judges will be called collegium. Okay. And it will contain Chief Justice of India plus 4 senior most judges of Supreme Court. They will take all decisions with respect to appointment of judges of Supreme Court. Now, what about High Court? Okay. Now, Article 217 Clause 1 deals with the appointment of High Court judges. The President, after consulting the Chief Justice of India, the Governor of the state and Chief Justice of High Court will appoint High Court judges. So, the appointment of High Court judges would also be made by President. But he has to consult Chief Justice of India, Chief Justice of the state High Court, Governor. Okay. Now the Supreme Court basically said that in this case also, Chief Justice of State would mean Chief Justice of State plus 2 senior most judges of that High Court. Okay. They will recommend candidates to CJI plus 4 senior most judges. Okay. That is the collegium. So collegium of the state, that is Chief Justice of State plus 2 senior most High Court judges, will recommend candidates to Collegium of India. They will tell the president which judges of the High Court you need to appoint. Okay, that's how High Court judges are appointed. And as far as transfer of High Court judges is concerned, that decision is also taken by Collegium of India. So Collegium decides everything with respect to judicial appointments, judicial transfers also, both Supreme Court and High Court judges. Now it is a closed system and people say that it lacks transparency, it lacks accountability. It is a closed system. Closed system has no place in democracy. Everything should be transparent in democracy. So to replace this system, well, the government thought that we will create a National Judicial Appointments Commission which will make all the appointments. Okay. So 99th Constitutional Amendment Act and NJAC Act was enacted in 2014. Okay. 99th Constitutional Amendment Act inserted the article 124A. Okay. 124A article of the Constitution, well, says that there shall be a National Judicial Appointments Commission. Okay. This National Judicial Appointments Commission would be responsible for appointing judges of the Supreme Court, appointing judges of the High Court, and would also make transfers. Okay. The members of this National Judicial Appointments Commission would be Chief Justice of India, he shall be the chair, 2 senior most judges, okay, Union Law Minister, and 2 eminent persons from civil society. Now, who will these 2 eminent persons be? Well, to elect or appoint these 2 eminent persons, a committee will be constituted. The committee will have CJI, Prime Minister, Leader of Opposition in Lok Sabha. These 3 people will choose these 2 eminent persons. Okay, from civil society. 1 eminent person should be from SC, ST, OBC, minority women. So this NJAC will make all the decisions with respect to appointments of judges. Clear? Makes sense? Now, one thing was added in this. It said that if 2 members of NJAC veto a candidate, they say that we are not happy with this candidate, then that candidate won't be elected as judge or appointed as judge. Even if 4 others are in his favor, 2 members can veto a candidate. Okay, this is NJAC. Now, to introduce NJAC, you had to amend the constitution. You had to introduce Article 124A, and that amendment was as per Article 368, which required 2/3 majority in both Lok Sabha and Rajya Sabha plus ratification of 50% of the states. Clear? So this was done, but this was challenged in the Supreme Court. And Supreme Court in 2014 called NJAC unconstitutional. Why was it called unconstitutional? It said that judicial independence, the Supreme Court said that judicial independence is part of basic structure of the Constitution. Okay, it is part of basic structure. Now through NJAC, through these 2 eminent personalities, well, the central government executive can interfere with the independence of judiciary. That is violation of our basic structure of Constitution. It is because of that NJAC was deemed unconstitutional. Okay, this judgment was given by a 5-judge bench of the Supreme Court with a majority 4-1 ruling. Clear? So this is your NJAC. Alright, now let's quickly shift to next topic, which is Lokpal and Lokayuktas. Okay, now what do you mean by Lokpal? Well, some of you might remember that there was this Andolan in India, or there was this protest in India called the Anna Hazare movement or Anna Hazare protest. It was India against corruption movement, fight against corruption in 2013 or 2012. Okay, basically Anna Hazare and his coterie and his protesters were asking for a Lokpal law. Under Lokpal law, there will be a Lokpal and he shall be empowered to investigate cases of corruption against Prime Minister, Council of Ministers, and all government employees. So basically, Lokpal would be eligible to investigate cases of corruption against everyone except judiciary. Except judiciary, he or she shall be eligible to investigate cases of corruption against everyone, every government employee in India, public servant in India. Okay, that would basically infuse more accountability in public servants. Okay, corruption would get reduced, and Lokpal should be given more powers to prosecute cases of corruption. Okay, so this movement was orchestrated, this movement was done, this protest movement was done so that Lokpal should be formed and he can prosecute not just a mere normal public servant, in fact the Prime Minister also. Clear? Now that protest actually yielded results and government had to enact Lokpal and Lokayuktas Act. Okay, Lokpal means he will basically Lokpal will prosecute or will investigate central government public servants, and Lokayuktas would prosecute or investigate state government public servants. Clear? Okay. So in India, Lokpal was enacted. So let's talk about Lokpal and how it is going against judiciary. Okay, what is Lokpal versus judiciary debate? We'll talk about this. Okay. So Lokpal. Basically, the idea of Lokpal originated with the idea of ombudsman in 1809 in Sweden. In Sweden, 1809, there was this idea floated called the ombudsman. Ombudsman would act as ombudsman would take care of corruption. He would be an outsider that would look after the cases of corruption against all government employees, all public servants. Okay, so he will be an external third party who would make sure that there is no corruption among public servants. Okay, so this idea of ombudsman was basically translated into Lokpal for the first time by Ashok Kumar Sen in 1960s. He said that a ombudsman-like institution should be there in India. He will be called Lokpal. Then in 1963, L.M. Singhvi said that Lokpal should be for center and Lokayukta should be for states. Okay, but then this process went on and nothing was done until Anna Hazare movement, Anna Hazare Andolan, and that Andolan was successful. Therefore, government announced that they are going to enact Lokpal and Lokayukta Act. So therefore, Lokpal and Lokayukta Act was enacted in 2013. Okay. Now, what will be Lokpal? So Lokpal will be an organization which will consist of a chairperson and a maximum of 8 members. Okay, half of those members should be judicial members, that means ex-judges, and 50% of the entire strength of Lokpal should be from SC, ST, minority, women, OBCs. Okay, now who will select these people, chairperson and 8 members? Well, there will be a selection committee that will select these members. Okay, Prime Minister would be a part of this selection committee, Speaker of Lok Sabha will be there, Leader of Opposition in Lok Sabha will be there, Chief Justice of India will be there, and an eminent jurist appointed by President. These people collectively will take a decision who will be these 9 people, chairperson and maximum 8 members. Now, what will be the jurisdiction of Lokpal? I mean, Lokpal can investigate corruption cases against whom? Well, he can Lokpal, this institution of Lokpal can investigate corruption cases against prime ministers, other ministers, MPs, and all group A, B, C, D government employees. Okay, clear? For state government public servants, well, Lokayuktas would be formed. Lokayuktas would take care of state, Lokpal would take care of center. Okay, that is why it is called Lokpal and Lokayukta Act. Clear? Now, this act was enacted. Clear? Though there are some issues in this act. I mean, government enacted this act and said, look, we basically did what you asked for, Mr. Anna Hazare and others. But those people said that government did not create a strong Lokpal. Okay, there were some issues in this Lokpal. Clear? What were those issues? First of all, Well, in 2014, BJP government came to power and Congress government had such low numbers that they couldn't make a leader of opposition. Because they couldn't make a leader of opposition, there was a vacancy in this selection committee, leader of opposition. Therefore, Government of India said that because leader of opposition is not there, therefore this selection committee won't work, and because it won't work, we won't appoint these people. Okay, so Supreme Court had to interject, and in 2016 government had to amend Lokpal Lokayukta Act saying that any vacancy in the selection committee won't stop the selection committee from making these appointments. Clear? This was the case. Plus, many state governments did not enact their own Lokayukta laws. So, Lokayukta institution was not that successful in states. Plus, in the center, Lokpal was suffering from various issues. What were those issues? First of all the members of Lokpal are appointed by government. Okay, most of the people in that selection committee are related to the ruling party. Therefore, there is lack of independence. Plus, the thing is that Lokpal will only hear cases of corruption where a complaint is filed against a public official. Okay, it cannot hear cases of corruption or it cannot investigate cases of corruption independently. A complaint has to be filed. So, no suo motu investigation. Plus, the thing is, in India, many people are scared of filing complaints against, well, powerful public officials because they fear that there would be action against them, right? So, therefore, they file complaints anonymously. But in this Lokpal, anonymous complaints cannot be filed. They are not allowed. So, already people are scared of filing complaints against big people. So, with this Lokpal, well, anonymous complaints were not allowed. So, not many complaints were coming. Plus, there is 7-year limitation period. If there is corruption, you can file a complaint at Lokpal within 7-year period. That was there. Plus, if you file a false complaint, there was heavy punishment. Okay. Plus, states were not implementing Lokayukta law properly. Okay. Plus, there was some issue with respect to section 44. You'll study about that in the notes. Okay. So, this is your Lokpal. Now, the thing is, what is the controversy? What is the current controversy? Hear me carefully. The thing is that Lokpal can investigate against public servants. That is what is written in the law. So, Lokpal can investigate against public servants. Okay. Now, who is a public servant? Any office or any authority in Government of India that is established by a law, okay, that has a statutory basis, would come under this definition of public servants, and Lokpal can investigate against that. Any constitutional authority, Lokpal cannot investigate cases against any constitutional authority. Okay, this is given in the Lokpal law. The thing is that Supreme Court is a constitutional authority, right? So, it does not come under the definition of public servants. Therefore, Lokpal cannot investigate cases of corruption against Supreme Court or judges of Supreme Court. But the catch is, as far as high courts are concerned, well, Constitution does mention, there are a lot of articles with respect to high court judges in our Constitution. But high courts in a particular state are established by a law of that state. Okay, law of that state. Basically, the state will enact a law which will constitute a high court for that state, or two states have one common high court like Punjab, Haryana High Court, right? So, states have to enact a law to establish high court. The powers of high court judges are given in the Constitution, but high courts are established as per the law of the state. Now, Lokpal recently, the Lokpal, the entire body of Lokpal, chairperson and 8 members, they ruled that since high courts are established by laws of parliament, high court judges would come under public servants. And therefore, retired high court judges can be investigated for corruption. right? So they gave this ruling. So Lokpal can now go against or investigate cases of corruption against High Court judges. Now a petition was filed in Supreme Court against this judgment of Lokpal, and Supreme Court has stayed this order of Lokpal. Supreme Court says that yes, High Courts are established by law of Parliament, but there is constitutional basis for High Court judges also. Therefore, they do not come under the definition of public servants. Therefore, Lokpal cannot investigate against High Court judges also. That is as per the recent judgment of Supreme Court, and you have to remember that. Clear? Make sense? All right. And now let's talk about next topic, which is ad hoc judges. Now look, our constitution is very clear about the strength of or the judges in Supreme Court and High Court. Sometimes the backlog of judiciary in Supreme Court as well as in High Court is very high. There are so many pending cases. Now to solve for this high backlog of cases, the Constitution has provided both Supreme Court and High Court two options. Okay, they can appoint retired judges, retired High Court judges or retired Supreme Court judges as ad hoc judges till the time this backlog is clear. Okay, so retired judges can be appointed as ad hoc judges in High Court as well as in Supreme Court. Ad hoc judges can be appointed. Plus, if a particular judge is not able to do his job because of illness or anything else, then for some time, until a new judge has been appointed, a particular judge can be appointed as acting judge. So this facility of acting judges and ad hoc judges is provided in the Constitution so that temporary emergencies can be tackled. Clear? Now, recently Supreme Court said that there is a lot of pendency of cases in High Court, right? And because of that, we need to consider this option of using retired High Court judges as ad hoc judges. Okay? Now, is there any constitutional provision with respect to that? Yes, there is. And what is that constitutional provision? Let's talk about it, okay? So, ad hoc judges. So, what does the Constitution says? First of all, what did the Supreme Court say? The Supreme Court suggested temporarily appointing retired judges on ad hoc basis to address the growing backlog of pending criminal cases before several high courts. Now, this facility of ad hoc judges is provided as per Article 224A. It allows Chief Justice of a High Court to request retired High Court judges to perform the duties of judge again with President's permission. So, if Chief Justice of a High Court feels that there is a lot of backlog, then he can request a retired High Court judge with the permission of President to be as ad hoc judge temporarily. Okay, that can be done. Now, Supreme Court in 2021 had stated that ad hoc appointments could only be made in certain situations. You cannot make ad hoc appointments willy-nilly whenever you feel like. Only a certain situations demand the appointment of ad hoc judges. Okay, and for that reason, in 2021, Supreme Court also created a memorandum of procedure. Okay. Yeah. First of all, before talking about this memorandum of procedure, let's talk about Article 224A, which talks about ad hoc judges. You need to know about the constitutional provisions as well. So the Constitution clearly says, Chief Justice of a High Court may at any time with previous consent of President, this is important, request any person who has held the office of a judge of that court or any other high court to sit and act as judge of a high court for that state. Okay. Now, if that person gives his permission to act as an ad hoc judge, then he will be taken as ad hoc judge. Now, what will be his salary or allowances? His salary or allowances as an ad hoc judge will be determined by the presidential order, and he will have all powers and privileges of a judge of a high court, but you won't call him a judge of a high court. He's just an ad hoc judge. Okay, he won't be deemed to be a judge of a high court. Now, Supreme Court in 2021 created a proper procedure. Okay, Supreme Court said that as per this memorandum of procedure, Chief Justice of High Court, okay, will select a list of candidates, will send that list of candidates to Collegium. Collegium will choose a person to act as ad hoc judge from that list, give the recommendation to the President, and then that ad hoc judge will be appointed. That was basically a memorandum of procedure, the exact procedure. You don't have to remember all of this. They won't ask questions with respect to that. Okay. So this was in the news. That's why I discussed the issue of ad hoc judges. Remember it because it was in the news. Chances are that they might ask you even static polity related questions with respect to ad hoc judges, because issue of ad hoc judges came in the news. Clear? That would be all. And now let's move on to our last topic of the day, which is impeachment of judges. Now, the thing is that recently, opposition party members of the India bloc, they wanted to basically introduce a motion of impeachment against a Allahabad High Court judge. Though opposition party members do not have numbers to pass this motion, okay, but they are still doing it for symbolic reasons. Okay. Now, this brings into question the process of removal of judges, and our constitution, to ensure judicial independence, has given a very strict and strong procedure for removal of judges. Okay, very strong procedure. Clear? So let's talk about that. Okay. So impeachment of judges, though our constitution does not use the word impeachment, but popularly it is known as impeachment. Impeachment means removal of judges. Now, the procedure for removal of judges of Supreme Court is mentioned in Article 124, and the process of removal of judges of High Court is mentioned in Article 217. But the process is exactly the same. The process for removing a Supreme Court judge is exactly similar to the process of removing a High Court judge. Clear? Now, how this process goes, hear me out. The thing is that apart from Article 124 and Article 217, which deals with High Court judges, there is a law which deals with removal of judges. Okay, that is known as Judges Inquiry Act. So this Judges Inquiry Act lays down the precise procedure that needs to be followed for removing a judge. Okay. Now the constitution is clear that if you want to remove a judge, a motion has to be admitted in Lok Sabha or Rajya Sabha. Okay. If you want to admit a motion in Lok Sabha, you need signatures of at least 100 members. If you want to admit a motion for removal of judge, either a High Court judge or a Supreme Court judge, in Rajya Sabha, then you need signatures of 50 members. If you have 100 members in Lok Sabha or 50 members in Rajya Sabha, then the notice is given for the motion, and the presiding officer of Lok Sabha, that is Speaker, or Rajya Sabha Chairman, will take a decision whether to admit this motion or not. Once this motion is admitted, either in Lok Sabha or Rajya Sabha, either of the house, let's suppose in Lok Sabha, then a committee will be formed. This will be a 3-member committee. This 3-member committee will contain retired judge of a Supreme Court, retired judge of a High Court, and an eminent jurist. Okay, this 3-member committee will inquire about the case of, will inquire why this judge is being removed. Okay, now our constitution is very clear. A judge can only be removed in case of proved misbehavior or incapacity. So you can only remove a judge in case of proved misbehavior and incapacity. Okay, proved misbehavior, judicial conduct, corruption and all. Incapacity, that the judge is not mentally sound to take decisions. Okay, only in case of proved misbehavior and incapacity. So once the motion is admitted, this 3-member committee is formed. Then this 3-member committee will investigate these allegations of proved misbehavior or incapacity. After the conclusion of their investigation, they will submit their report. And if in this report it is found that yes, the judge has showcased the case of incapacity or proved misbehavior, then this matter will be put to vote in Lok Sabha itself. Okay, in Lok Sabha, if you need to pass the resolution to remove the judge, then that resolution should receive votes of 2/3 members present and voting, and it should cross half the total strength of Lok Sabha. Once it is passed by Lok Sabha, it will be sent to Rajya Sabha, and similarly in Rajya Sabha it requires 2/3 membership, 2/3 members present and voting, and total membership of the House, half of total membership of the House. Okay. Once it is passed in both the houses, then it will be given to the President, and then the President will release the order of removing a judge. That is how difficult it is to remove a judge. That is why, well, many people say that if judges are accused of corruption and all, there is no recourse, because it is difficult to get this much majority to remove a judge. Okay, it is that difficult that yes, motions have been passed, inquiries have been made for removing judges of high courts or Supreme Court, but no judge has been removed in India's history so far, Supreme Court or High Court, because it is so difficult, right? You need to get so many numbers in Parliament to remove a judge. That is why no one has ever been removed. Make sense? Now, this is the procedure that you should be familiar with. Just remember, the procedure for removal is mentioned in Article 124 for Supreme Court, 217 for High Court, and the detailed procedure is given as per Judges Inquiry Act. Okay? All of this taken together give you this detailed procedure, and you should know about this detailed procedure because questions might be asked. Clear? And that would be all. With that, we conclude today's session. Now, please do not forget to revise this lecture. Okay? The notes for this lecture shall be shared on your Telegram channel. So make sure you go to the Telegram channel, download these notes, and then revise this lecture from those notes. Only then I would consider this lecture to be complete for you. Okay? I hope you understood everything in this lecture. But if you really want to remember it till your exams, please do spend 15 to 20 minutes revising this also. Alright? And on that note, I'll be signing off with the promise of seeing you again with another lecture of Prelims Powerplay series Polity session. Thank you, everyone.